Man, the drums at the end where it's like boom, 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 boom. Man, it gets you hype.
Okay, so let's go ahead. The TLDR. By the way, I'm John Crump. I'm an investigative journalist. This is Flying Rich. He is my co-host on John Crump Live, and this is DLD after. This is Dark from DLD After Dark. We are broadcasting to Black Swan Media on Facebook, John Crump News, Flying Rich Firearms, DLD After Dark, John Crump Live, whatever, Twitter. Or X, whatever you want to call it now, and Twitch. So let's go ahead. We're going to talk about what is going on, but the TLDR, the Vanderstock case, has a decision, and this is out of the Fifth Circuit Court of Appeals, and it vacates the majority of the rule, of the 80% rule, and remands it back down to the district court judge to issue the rest. But as of right now, the rule is vacated. We're going to go ahead and get into this, and we're going to discuss it. So if you want to discuss it, have any questions or anything else, let me know. I do know a lot of stuff has been going on today, and this is a bad week for the ATF, which is a good week for all of us. So
can we get at least one Jamaican horn for this win right here, for this big win, like something like that. Dude, this is a huge win.
Yeah, let's go ahead and start this here. We are going to go ahead and bring this up. Let me just get the right one up.
Get it up, John.
Why is this not working?
Do you need some help?
It's not that hard.
No, I got it right here.
Heyo.
Yeah, for some reason it wasn't showing up in the preview window, but it is showing up if I just bring it up. So here we go. So of course, this is out of the Amarillo division here. Actually, no, this is the wrong one. Hold on. Wrong case.
Mike Hunt?
No, I was just putting in the wrong case here. Just give me 1 second.
Everybody out there in the chat showing some love for CRS Firearms, aka Matt Hoover. I was actually finally I got my account set up, and I am exchanging emails with Matt Hoover. He misses all of y'all. He loves all of y'all, and is grateful for all the support.
Now known as by his cellies, MGH.
MGH.
Machine Gun Matt.
Oh.
Machine Gun Hoover.
Machine Gun Hoover. Nice. Mm-hmm. That actually makes sense. But he's never had a machine gun. Well, that's okay. Go ahead.
Actually, he's had machine guns. Just not the one.
He was an SOT.
Not auto key cards.
Yeah.
Right.
All right. So we're going to go ahead and read through this. This is Vanderstock. This is out of the Fifth Circuit. This is Vanderstock versus Garland. This is... Stop.
Sorry.
This is the case that is brought by Firearms Policy Coalition and Black Hawk Manufacturing, which is 80% Arms, Defense Distributed, Second Amendment Foundation, JSD Supply, Polymer 80, and others.
Mm-hmm.
All right. Who's getting Cody Wilson for a comment?
I will get Cody and also Jordan. So... Okay, so let's just start reading here. The decision is 60 pages, which isn't long.
Well,
It has
60
long
pages.
been said. Who do you want? You want me to jump in?
Whoever.
Go for it.
It has long been said correctly that the law is the expression of the legislative will. As such, the best evidence of the legislature's intent is in the carefully chosen words placed purposefully into the text of a statute by our duly elected representatives. Critically, then, law making power, the ability to transform policy into real world obligations, lies solely within the legislative branch. Would you look at that? What? No way, guys.
We'll get to super chats as we go through this. So
Where an executive agency engages in what it is, for all intents and purposes, lawmaking, the legislature is deprived of its primary function under our Constitution, and our citizens are robbed of their right to fair representation in government. This is especially true when the executive rule turned law criminalizes conduct without the say of the people who are subject to its penalties. The agency rule at issue here floats clear statutory text and exceeds the legislative
flouts.
imposed flouts, sorry, legislatively imposed limits on agency authority in the name of public policy. Because Congress has neither authorized the expansion of firearm regulation nor permitted the criminalization of previously lawful conduct.
Yes.
The proposed rule constitutes unlawful agency action in direct contravention of the legislature's will. Accordingly, for the reasons set forth below, we affirm in part and vacate and remand in part the judgment of the district court.
All right,
Yes.
so that is awesome. Basically, the rule is dead. We have a super chat here, so let me go ahead and play the little chime here. Riptide with the $49.99 super chat. Rich, go ahead and read it.
Wow.
First braces. Now this, hopefully, the Supreme Court kicks the ATF's teeth in with the bump stock case to defeat Chevron deference and these BS rules. Amen, brother.
Yes.
Yeah,
yes.
Chevron deference is a huge problem. Chevron deference is basically if a law is ambiguous or unclear, the agency gets to decide what it means. But the thing is, Chevron deference was only ever meant for administrative stuff, like civil stuff, not criminal. But yet the ATF expanded it with the bump stocks to criminal.
Yep.
Another super chat, $2 from Putin, Bob over at JSD Supply, who works for the company that is named in one of their things. The book Master of Firepower makes a great gift. That is true.
Very true. Also, you can even get a signed copy where Mr. Crump will write your mom's box.
I will
Oh,
send
you got something pleasant like that. I got something less pleasant.
All right, but let's just keep on going. This is statutory background and stuff like that. Basically, it explains the rule. We don't really have to go through this because we went through this on every other time we've talked about this rule. So I'm just going to skip the whole entire statutory thing.
Yeah, the reality is that if you're here, then you already understand all of this, and that you know what the ATF was doing was absolutely absurd.
Now, is Jordan in the chat? Is Jordan going to sell polymerides again?
I don't know. Well, let's just get through this, then we'll answer those questions.
All right, where do you want me to go back to?
Okay, factual background. So it basically says this is basically saying that that they sued what the district court said with the preliminary injunction. It goes through the whole entire thing that happened with the case so far, which everyone is aware of. So let's just start with 3, standard of review.
All right. Standard of review. We review a grant of summary judgment de novo. I have no idea what that means. Viewing all the evidence in the light most favorable to the non-moving party and drawing all reasonable inferences in that party's favor.
It means basically
law.
like a new judgment.
Yeah. The court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact, and the movant, but I don't know, I'm not a lawyer, is entitled to judgment as a matter of law. In case
that's the plaintiff.
Oh, gotcha.
Basically.
The plaintiffs challenged two portions of the final rule in the underlying lawsuit. One, ATF's proposed definition of, quote, frame or receiver, including incomplete frames and receivers, and two, ATF's proposed definition of firearm, including weapon parts kits. I don't like that terminology, but whatever. We analyze each challenge portion of the final rule in turn below before addressing the appropriate relief should these specific portions of the final rule be held unlawful. At the outset, we must ensure that we look through the proper lens when analyzing the AFT's actions here. It is axiomatic that an administrative agency's power to promulgate legislative regulations is limited to the authority delegated by Congress.
Basically, it's that's saying that they can only do it if Congress gives them the authority to. We can skip all this. Good.
referencing
Read this. This
DCA.
is actually a very important.
So it says, to be sure, agencies, as mere creatures of statute, must point to explicit congressional authority justifying their decisions. In the GCA, the source of the ATF's capacity to promulgate the final rule, Congress delegated authority to ATF through the Attorney General to, quote, prescribe only such rules and regulations as are necessary to carry out the provision of this chapter. You may keep going.
Hold on, I just want to say something. With the rule about firearms dealers, the ATF is trying to get around this. This is why I think they know they're going to lose by trying to state that the Bipartisan Safer Communities Act gives them the authority to redefine who is a firearms dealer. So I'm pretty sure they know they're going to lose here. So that is, and that's the reason why they knew that was a losing argument. So go ahead.
Yep. Let's see, where do we leave off here? Chapter.
Such a grant.
Such a grant of authority from the legislature to an executive agency is generally policed by the Administrative Procedure Act, or APA, which
we learned about
allows
the APA yesterday. The race rule ran afoul of the APA, and this one does too. So keep on going.
Yep.
Sorry.
Which allows courts to set aside agency action found to be, among other things, in excess of statutory jurisdiction, authority, or limitations, or short of statutory right. Thus, a core inquiry in a case such as this one is whether the proposed agency rule is a lawful extension of the statute under which the agency purports to act, or whether the agency has indeed exceeded its statutory jurisdiction, authority, or limitations. How do we know when an agency has exceeded its statutory authority? Simple. The plain language of the statute tells us so. Therefore, we start, as we always do, with the text. And then there's case
Just
law.
get down here. Start down here.
The best evidence of Congress's intent is the statutory text. In statutory interpretation disputes, a court's proper starting point lies in a careful examination of the ordinary meaning and structure of the law itself.
Let's get down to here. Reread.
Here we read the words of the GCA, quote, in their context and with a view to their place in the overall statutory scheme, that's case law, where to go, only where the statutory text shows that the ATF has, quote, clear congressional authorization to enact a regulation can such a regulation withstand judicial scrutiny.
Okay.
And
so this is basically, we're going to skip a lot of this. This goes the proposed definition of frames and receivers.
Most of their explanation, even in the GCA, doesn't even apply to most.
All right, well, just get under
because Congress did not define, quote, frame or receiver. Excuse me. In the GCA, the ordinary meaning of the words control. See case law. Both a, quote, frame and a, quote, receiver had set well-known definitions at the time of the enactment of the GCA in 1968. In 1971, Webster's dictionary defined a, quote, frame as the basic unit of a handgun, which serves as a mounting for the barrel and operating parts of the arm. and a, quote, receiver as the metal frame in which the action of a firearm is fitted and which the breech end of the barrel is attached. References Webster.
Yeah, basically saying that you're saying that there's no definition, but here it's everywhere.
Now, do you think, well, we'll come back to it. After almost 50 years of uniform regulation, ATF, via the final rule, which they changed several times, now purports to expand the terms frame and receiver as they were understood in 1968 to include changes in firearms in modern times. But the meanings of statutes do not change with the times. See this case law, blah, blah, blah. This court normally interprets a statute in accord with the ordinary public meaning of its terms at the time of its enactment. After all, only the words on the page constitute the law adopted by Congress and approved by the president. ATF's inclusion now of, quote, partially complete, disassembled, or non functional, which was very ambiguous wording, frames and receivers materially deviates from the past definitions of these words to encompass items that were not originally understood to fall within the ambit of the GCA of 1960.
It's saying that the Congress never intended that to be part of the GCA, and you cannot just shoehorn it in there because you decide to.
Yeah, you can't just make a rule.
The meaning, and we have another super chat here, so let's go ahead. I do want to deal with this. This is totally different. I'm not saying the Supreme Court won't stay this because they probably will. But as of right now, Rich, go ahead and read. Something to read more next.
Wait. On Josiah Hope all is Giuseppe Zanti in the boots of Timberland Pass and High Crump and Rich.
All right, thank you for that. $5 super chat.
Now, something original. I hope you're okay because that seemed seriously odd. Coming from a guy who shot himself in the hand with a 32 ACP. I hope you're well. And why didn't you say hi to me, bro? What the hell?
All right, let's continue.
All right, so where do we leave off? It got scrolled and I lost it. Oh, thank you. A plain reading of the final rule demonstrates ATF's error in the GCA's definition of firearm. The first subsection includes flexible language such as designed to or may readily be converted to expel a projectile by the action of an explosive. See 18 U.S.C. blah, blah, blah. But the subsection immediately thereafter, which contains the term frame or receiver, does not include such flexibility based.
I will share right now. It is only on Pacer, which is like a Pacer or so.
Excuse me. So sorry, guys. When Congress includes particular language in one section of a statute, but omits it in another section of the same act, it is generally presumed that Congress acts intentionally and purposely in the disparate inclusion or exclusion. ATF's assertion that Congress has repeatedly used language such as designed to and readily in other definitions or statutes only emphasizes the point. Congress explicitly declined to use such language in regard to frames or receivers. Thus, we presume the exclusion of the phrase designed to or may readily be converted in the frame or receiver subsection to be purposeful, such that ATF cannot add such language where Congress did not intend it to exist.
What they are trying to say is that the ATF tried to shoehorn that phrase in there, even though that phrase is not part of the definition of a firearm.
Yeah.
It sounds like it, but from another piece of that legislation.
Yeah, and also technically the AR-15 upper and lower only collectively fits their description in the 1960 GCA.
That is correct.
So do you think this could potentially have an impact on that in the future?
Well, they didn't challenge the part of the rule saying that the ATF gets to determine what constitutes the required serialized version of it. That wasn't challenged in that, so I don't think that's gonna. There's other cases that I think might bring that up, but I don't think this is the case.
Okay, I was just curious. There is also a clear logical flaw in ATF's proposal as written. The final rule states that the phrase, quote, frame or receiver includes things that are admittedly not yet frames or receivers. Imagine that. But they can easily become frames or receivers. In other words, parts. As the district court put it, under the final rule, ATF may properly regulate a component as a frame or receiver, even after ATF determines that the component in question is not a frame or receiver. Hold on. There's one more piece
All
here.
right, let's just go down here.
Well, such
The government-
propositions defies logic.
Let's just go down to the government argues.
The government argues that ATF has historically regulated parts that are not yet frames or receivers as frames or receivers, thus making the final rule a valid extension of past agency practice. This argument fails for two reasons. First, as the district court aptly stated, historical practice does not dictate the interpretation of unambiguous statutory terms. Simply because ATF may have acted outside of its clear statutory limits in the past does not mandate a decision in its favor today. Dang. Second, the government's current argument, excuse me, guys, sorry. The government's current argument regarding the readily converted language is as it applies to frames and receivers as it is at odds with its recent arguments in other courts. For example, in its briefing
This
case,
is very important because the ATF tries to always say one thing one place, one thing in another place.
Of course, yeah, they argue their own points against their own points. For example, in its briefing for a case,
Omar, once I get it up, it's right now. It's only available on Pacer, so which is a paid service. I'm going to get it up on something else, so just bear with me.
For example, in its briefing for a case in the Southern District of New York in early 2021, the government stated that the designed to and readily converted language are only present in the first clause of the statutory definition. Therefore, an unfinished frame or receiver does not meet the statutory definition of a, quote, firearm, simply because it is designed to or can readily be converted into a frame or receiver.
Ouch.
Clearly, the government has arbitrarily reversed course since authoring the Syracuse brief, yet it offers no explanation for its new regulatory position. Dang. Man.
Yeah, I'm okay. I'm putting it in there. I got it uploaded to Scribd.
I'm impressed. I am impressed.
All right. Let's then it goes into ATF proposed rule for a firearm. So I'm going to skip the first because just go down to this line here, the district court.
The district court correctly held that ATF has no authority, I repeat that, no authority whatsoever to regulate parts that might be incorporated into a firearm simply because Congress explicitly removed such authority when it enacted the GCA. The GCA, which is the Gun Control Act of 1968, for people just joining us because we just hit over 400 viewers, predecessor statute, the Federal Firearms Act, FFA, had specific language that authorized regulation of, quote, any part or parts of a firearm. However, Congress removed this language when it enacted the GCA, replacing any part or parts with just the frame or receiver of any such weapon. Thus, the GCA does not allow for regulation of all weapon parts. Rather, it limits regulation to two specific types of weapon parts. The final rule ignores this change completely and improperly rewrites and expands the GCA where Congress clearly limited it.
Basically, they're saying that, hey, you didn't like what it said, so you try to make your own law up, and you can't do that.
Absolutely, yeah. And there, I would think that something like, West Virginia versus the EPA, I would have thought that would have had an impact on like Chevron deference. And
that was a very, very narrow ruling. And when that came out, I tried to explain that to people. but not everyone listened.
I didn't listen.
All right.
Further, Congress has shown that it let me get my cursor here. Further, Congress has shown that it knows how to regulate, quote, parts of weapons when it so chooses. For example, section blah, blah, blah of the GCA in defining a, quote, destructive device, one of the 4 subsections of the firearm definition.
Okay, we can stop right there. Basically, they're saying if Congress knew what they were doing and if they wanted to regulate firearms parts, they would have, but they did not. So therefore, they didn't really want to regulate firearms parts.
Yeah.
All right, get on here.
ATF finds its primary justification for regulating weapon parts kits in, quote, or in the, quote, designed or may be readily converted to language in the GCA's definition of firearm. The government argues that the statute captures any item or items that may be transformed, meaning changed and altered, or changed into a working firearm based on the dictionary definition of convert. At the time of the GCA's enactment, because weapon parts kits allow individuals to, quote, convert various parts into an operational firearm, the government argues the final rule's proposed definition falls clearly within the GCA's ambit. Continue.
Yeah.
But this stretches the words too far. Thank you. The government wants the word convert to be all encompassing, such that any process of or procedure that could ultimately lead to a finalized firearm can be regulated under the GCA's language. The
Remember
language,
remember when they said that readily convertible is 8 hours in a machine shop?
in a machine shop, yep, and
Fully
that,
equipped.
yep, and that an aluminum disc at Home Depot was a silencer. I mean, it's crazy.
We'll get to the super chats in a minute. So
the language, however, is much more precise than that. In fact, the government's emphasis on the word convert ignores the surrounding words. The GCA does not just regulate anything that can be converted, or, to use the government's proposed synonym, transformed into a firearm, but rather regulates any weapon that may readily be converted into a functional firearm. The phrase may readily be converted cannot be read. Scroll down for me. To include any objects that could, if manufacture is completed, become functional at some ill-defined point in the future. This would strip the word readily of its meaning, revert the GCA to its prior articulation in the FFA, and allow for regulation of weapon parts generally, which, as we have seen, was not Congress's intent in passing the GCA. Look no further than the words ATF used in the final rules proposed, quote, firearm definition. It includes weapon parts kits that, quote, may readily be completed, assembled, restored, or otherwise converted to expel a projectile.
You just got on reading converted.
At reading converted in conjunction with other listed verbs, completed, assembled, restored, we can see that the definition itself contemplates less drastic measures than the full transformation actually required by these parts kits. When general words follow an enumeration of things, such general words are not to be construed in their wildest extent, but are to be held as applying only to things of the same general kind or class as those specifically mentioned. The government's attempt to use the word convert to justify its unprecedented expansion of the GCA thus collapses upon a cursory reading of the text. Man, I'm impressed. The government responds that courts have long recognized that disassembled or non-operational weapons constitute, quote, firearms under the GCA, and cites our decision. Thank you. In United States v. Riles.
That's a really old case. That's a 30-year-old case.
There, a defendant was in possession of a disassembled firearm, in that the barrel was removed from the stock and that it could have been assembled in 30 seconds or less. We held that because this disassembled shotgun could have been readily converted to an operable firearm, it constituted a firearm under the GCA. Unlike
Basically,
the
I removed the
firearm,
barrel, and he said it's not a firearm anymore because the barrel's not attached.
that's big brain stuff right there. It constituted a firearm under the GCA. Unlike the firearm in Riles, weapon parts kits are far from being operable. Thank you. They wouldn't listen to us, but they'll listen to you, buddy. Assembling a weapon parts kit takes much longer than 30 seconds, and the process involves many additional steps. Because of these differences, weapons parts kits are not readily converted to an operable firearm, and thus they do not constitute firearms under the GCA. Mother.
Yeah, we're gonna skip some of this, but it goes into
Skip it
the
up, baby.
history of firearms making and stuff like that. So let's go ahead and skip down to public policy concerns.
The government and Amici, is it Amici?
Mikai.
Yeah.
Amic, whatever, argue.
Basically, what that is friend of the court.
Yeah.
It's like outside parties that file amicus or amicus, however you want to say it, briefs with the court. It's like
Gotcha.
unrelated parties.
Argue that the challenged portions of the final rule must be upheld to promote important public policy interests and carry out the essential purpose of the GCA. They point to serious concerns regarding public safety, the apparent rise in criminal usage of ghost guns, and the current difficulties in firearm tracing for law enforcement. Without the final rule, they argue bad actors will use the substantial loopholes in the text to completely circumvent the GCA and ultimately gut the law entirely. However, the fact that later arising circumstances cause a statute not to function as Congress intended does not expand the congressionally mandated narrow scope of the agency's power. Case law, likewise, an administrative agency's power to regulate in the public interest must always be grounded in a valid grant of authority from Congress.
Okay, skip down to here the as, because this goes into Cargill.
As this court stated in Cargill v. Garland, it is not our job to determine our nation's public policy. That solemn responsibility lies with the Congress.
Yeah, that's all I wanted to read right there.
Beautiful.
Basically, it's saying you cannot decide public policy because it's not your job. That's Congress's job. And let's go down to the remedy here.
We turn now to the appropriate remedy. The government argues that the district's court universal vacator of the entire final rule, i.e., not just the two challenged portions, was overbroad, regardless of the merits of the case. While this court's precedent generally sanctions vacator, is it vacator? Vacator?
Yeah.
Under the APA, we vacate the district court's vacator order and remand to the district court for further consideration of the remedy, considering this court's holding on the merits. Conclusion: ATF, in promulgating its final rule, attempted to take on the mantle of Congress to, quote, do something with respect to gun control. But it is not the province of an executive agency to write laws for our nation. That vital duty, for better or for worse, lies solely within the legislature. Only Congress may make the deliberate and reasoned decision to enact new or modified legislation regarding firearms based on the important policy concerns put forth by the ATF and the various amici here. But unless and until Congress so acts to expand or alter the language of the Gun Control Act, ATF must operate within the statutory text existing limits. The final rule impermissibly exceeds those limits, such the ATF has essentially rewritten the law. This it cannot do, especially where criminal liability can and, according to the government's own assertions, will be broadly imposed without any congressional input whatsoever. An agency cannot label conduct lawful one day and felonious the next. Yet that is exactly what ATF accomplishes through its final rule. Accordingly, the judgment of the district court is affirmed to the extent it holds unlawful the two challenged portions of the final rule and vacated and remanded as to the remedy.
All right. So this is concurring judgment. These are different judgments. He agrees, but for a little bit different. There's some pictures of firearms and stuff like that. But
Are there any pictures of jigs in there by any chance?
Yeah, like unfinished firearms.
Yeah.
So we're going.
Are there any pictures of photo key cards?
No. So this is and this is signed by the deputy clerk of the court.
Excellent.
Woohoo!
Wow.
All right. So it didn't completely strike it down, did it?
No. There's a couple different provisions. There's a couple different provisions that I didn't touch because those weren't challenged. Those are like the solvent trap stuff.
So what is the current status with solvent traps?
Since that was not touched, they still up in the air. It could be knocked down totally, but as of right now, that part is not knocked down.
So,
frames and
in other words, what they're saying is 80% frames and receivers are legal as of now, mofo. Yeah. The other stuff, solvent traps, could be adjudicated at a later point in time because it was remanded to the lower court for that decision.
All right. Let's go ahead and hit some of these super chats here. It is nationwide, and vacated means what? It means that the rule is been thrown out, non-existent,
tossed in the garbage.
So does this mean that? All right, go ahead, Rich. Sorry, I'm taking your job.
So does this mean that 80% arms can start shipping stuff now? Because I got a huge order on standby. Damn right it does.
I bet you that they're probably working overtime to get it shipped out
right after they celebrate.
Does this mean Invader Zip website, I can't say the other part, can ship stuff? Oh, well, it was never a parts kit.
Yeah. It just parts.
So that is it. 80% arm now can ship. Polymer 80, they still had an injunction under another case. I would not be surprised if the government is going to go ask the Supreme Court of the United States to step in and stay the vacator of the rule until...
So the vacator was not stayed. They're like, now, mofo, now.
Yeah. They didn't say we're going to stay for a week or anything. It's
okay.
It's done. But the federal government is going to go to SCOTUS and ask them to step in and stay the decision.
I got to be honest.
Can we set our watches?
I guarantee you they're working on it right now. Like, guarantee it's already done, and they were just waiting.
Yeah, I could see that for sure. I got to be honest. I have never been so excited to take such a negative impact on my business for jigs. But I always said, and I always took this stance, that I would rather see freedom, independence, and liberty across the country than, my own personal gain. So, and there may be people out there that still need jigs that, maybe just bought a frame or something. But dude, this is a beautiful thing, and I'm excited to see it happen. This has crushed the gun building, mostly Glock building industry. There has been just a straight freeze on purchasing, and not only purchasing frames and jigs and rails and bits and all that, but the parts as well. Companies out there are struggling because so many people just were stuck and they didn't know. They didn't know what was lawful, what was legal, what was illegal, and they just stopped building for a long time. So I'm excited. We need to get this news and information out so people can get back to building stat.
I want to hit on something. Readily convertible. Readily convertible never applied to a part. Readily convertible applied to a firearm that was deactivated. What was happening?
The 2023 case, basically what happened was the 2023 case. Don't do that, dude. They'll strike us for that. You're muted, Dark.
I already took it down. You put it back up, but they're not going to strike you for jigs.
You never know, man. But the thing I am talking about is the 1993 case. It was some guy took a shotgun, removed the barrel from the shotgun, and then they said it's readily convertible because all they had to do was put the shotgun back on. I would put the barrel back on.
Right, all right. But the GCA, when the GCA was put into law, what it was referring to was starter pistols that you could get from Italy that had a lead ball in the barrel. That all you had to do is push out the ball, and you had a pistol again.
Yeah.
So it was talking about a firearm that was a firearm, was disabled, but was readily convertible. It wasn't talking about a frame or receiver. It was talking about a firearm, not a part.
That is cool.
Barton Fink brings up a good point here. Now, this ruling could be good or could be great for old gun parts kits, so barrels don't have to be torch cut. Do you think that could potentially give ground for something like that in the future?
No.
No?
I honestly don't think that's that's going to be the case. There's other challenges that can challenge that. I don't think this will be the case that challenges it.
Gotcha. Well, and also if those were like, let's say AKs for an example, if those were ever machine guns, those are going to need to be, cut anyway.
Yeah. So
I'm just going through reading chat. Sorry.
Yeah. So that is okay. Let me just do this one. Glock switches were never legal, so they can never be considered in common use in the eyes of the federal government.
Yeah. Free CRS today. Absolutely. And he's just getting so burned, man. It's wrong.
Why are you title so weird? Frames role vacated. So the role is open? Good old Joe. Come on, man.
Come on, man.
Come on, man. I got hairy legs.
We hold these truths to be self-evident. All men and women created by you know the thing. Come on, man.
There we go. All right.
What's this got to do with? I'm sorry, real quick. What's this got to do with the auto key card case? Nothing at all. Just because we're all connected to CRS, a lot of people come in and showcase their hatred for the DOJ and the ATF for doing something terrible. So we all have that.
Just say this. That's what I was saying. I do expect that to happen. What I said is that I'm sure that the ATF already had their documents written to go.
Right. Yeah. If you're good at your job, you're going to be preparing for the worst. You're going to have that written out and just ready to push the button send.
Put it this way: when Stimbolier went down to Florida to defend us when they tried to gag us, we had an appeal all ready to go. We didn't have to send it because we won, but we had one ready.
Yep.
Eli EDC out there, how are you doing, my friend? Who is a part of the case up in North Dakota on frames and receivers.
He says, hello, did I miss something? Yes. You missed 44 minutes.
Can this help Patrick Tate? I'm not sure that it can. I hope it can, but it depends on his lawyers. I'm definitely going to get it over to those guys over there. Patrick Tate is a guy down in Virginia Beach that was set up by the ATF and accused of selling machine guns because they weren't demilled right, even though he bought them from Gunbroker. And he also bought a demilled RPG with no trigger pack from a flea market, and the ATF patched up the holes and installed a trigger pack and said, "Oh, it's readily convertible."
So ridiculous. I mean, it should be able to, but look, I mean,
and
what
he was a decorated Navy guy, decorated sailor.
Yeah.
Yeah,
Now,
and he was still in the Navy. He was an exemplary sailor.
And he was
destroyed.
set up.
Yeah,
It was definitely a setup. The guy said, "Hey, can you?" The ATF informant said, "Hey, can you buy this? I don't have a Gunbroker account. I know you do. Can you buy this and then sell it to
That's where you go. Danger, Will Robinson. Create an account. Let me help you.
Yeah, well, whatever. It was definitely a setup.
I mean, look, the crazy thing is that all of these were imported into the United States per the standards and laws that we have set in place already. So they were approved to be brought into the country, but somehow were illegal once he possessed them. Like, this is insanity. And this is the same shit that they try to get away with all the time. And they are ruining people's lives. It's just very odd that they're only ruining military age males that are armed. I don't know. Interesting.
Yeah. It really is. Not only military age male, military member.
Yeah. Actual military. Yeah, that's crazy, man.
Yeah. So that is it. Is there any other questions before we get out of here?
Looks like some more people are jumping in. Maverick says, "Just got here. Can we get a real quick rundown?" You want to give him the 5-second?
P80s are always good to go. There was a different injunction that Polymer 80 had. This basically cleared the path for everyone else.
Yeah.
So basically, any polymer pistol frame receiver that you can buy as a kit to build a firearm from is legal as of right now.
Yeah.
It's funny that
so place that order.
I know basically everyone who sued.
Yeah,
Just give it a second. The Amendment Foundation, Blackhawk, JSD Supply, Polymer.
Where's JSD?
He was in here earlier.
I saw him.
Yeah.
Do we get a statement? Do we get a statement from Jordan?
No, I mean, I'll reach out.
I would guess Jordan is going to wait this out a bit to see if the Supreme Court.
80% are not firearms as of right now. But yes, it does mean the MUP can be sold. But I do believe this is going to go to the Supreme Court, and they are going to ask for it to be stayed.
Yeah.
All right.
Pistol braces.
Does Jordan want to come on?
Since yesterday, we're A-okay.
Yep. You know, this is a really...
Now you can build an 80% firearm and stick a pistol brace on there.
Yeah.
That's a big FP. I might actually do that.
Yeah. You know what? I got... What were those?
While live streaming on YouTube.
Polymer 80 braces with the little foldy brace.
Well, I do. I have one in the other room. I have a Polymer 80 with a pistol brace in the other room.
Yeah, I got the same thing right here. What were they called? Dang, I totally forgot the name. But they're dope though. It's like a little brace chassis for a pistol.
Recover tactical.
That's right, Recover Tactical.
Yeah.
Not the macaroni. The Recover Tactical is small, doggy. Super small.
Yeah, the Recover Tactical is very small. I'll bring it up.
No, they did not make them up for the 365. There's one portion of the fire control unit which is like almost impossible to from what I understand to recreate. But yeah, I don't know what the future holds, so we'll see. And like they're saying, prepare for the government to come back and and fight this, and we may end up in a completely different position doing another stream tomorrow or in a few days. Who knows?
Yeah, they're definitely going to fight it, and I'm not 100% confident that they're not going to. I hope they don't. But
Let's just celebrate when we can. All right.
yeah, this is the recover tactical.
Yep. That's it right there. I never liked that little doohickey in the back. You can still charge it, especially if you're running like a 17 or 34. But you can still manipulate the slide without that little weird square thing in the back.
I do.
Yeah.
I don't have the square thing in the back.
Yeah, I don't have one either.
But yeah, that is it. Let's see here. Any other questions before we go? Andy Lipsco is quoting you, Dark.
Quoting me? What did I do? What did I say?
About how the government hates us.
Oh.
No.
Our government hates us and wants us dead. That is my thing.
Joe Biden wants to know Joe Biden wants to know what's wrong with a vertical grip. Nothing in my eyes.
Nothing at all.
Or advice is not legal advice.
That increases the FPS of your baby killing magazine, your high capacity Google search. I don't know. Whatever they say, they don't know. They have no idea what they're talking about. What's for dinner? That's an excellent question. I'm hungry. I gotta get one for my large frame now. That would be dope for a 10 millimeter or a 45 ACP. I want one for the OEM Glock. I love mine for my polymer 80s, and you guys can see I love my P80s. I've built dozens and dozens of them, but there's just something special about an OEM Glock. You know what I'm saying? I just love it.
Now, was it a 3-judge panel or the whole circuit? Who made this decision?
This right here was a 3-judge panel, but it's not. I mean, it was a 3-judge panel, but I don't think that they're going to ask for en banc. They might ask for en banc, but they're going to lose if they go to en banc, and they know this.
Mm-hmm. Mm-hmm.
So they don't have to go en banc. They can go directly to the Supreme Court, which I believe is what they're probably going to do because they're going to get crushed on the en banc. The en banc ruled 13-3 for bump stocks. So there's no way, there's no path to victory in the Fifth Circuit Court. And the ATF lawyers, they're not dumb, and they know that. So I doubt that they're going to go for en banc.
Hey, I'll have you know, I've lost like 15 pounds, buddy. All right. Check out these guns. I'm just kidding. That's mean though, pig snuffer. Jeez, gosh. Maybe it's the angle. The angle. You know what I'm saying?
NFA is going to have to be dismantled piece by piece. I don't see it happening all at once. I wish it would, but I just don't see that happening. I see it being dismantled piece by piece, though. But that's just me.
You mean like all in one swoop? You don't see it happening like just NFA is.
Yeah. I see it being dismantled piece by piece.
Yeah.
Because there's been so many cases trying to wholesale get rid of it, and they've all failed. And people are going to keep on asking for it. In fact, the Texas versus ATF down in Florida, one of the arguments is that the NFA is unconstitutional.
Yeah, 100%. It is.
Which can open them up to knocking it down, but I don't think that they will.
Yes, Crack Scout. Somebody else mentioned something else. What was it? Just from the turkey's video, you look like you slimmed down a little bit from shot. Well, thank you, sir. So this is why P80 has been holding my order for the last 6 months. No, that's just the way
No,
they do
they had an
business.
injunction. They could have delivered
P80 had an
anytime.
injunction. They get it shipped any time they want.
Welcome to being a Polymer 80 distributor, buddy. Congratulations. If you would like to exchange war stories, you could reach me at dude, it's crazy, but we probably shouldn't discuss that on a public format.
Yeah, I'm not really sure. I'm not a Polymer 80 distributor. I've never had any issues with Polymer 80, so I don't know about that.
I've never had any issues with their products. I've never had any issues with, and I love
But
their products.
I've only been a customer. I've never been a distributor, so really can't speak to that.
Yeah, it's different. They fill orders whenever they want. They sometimes ship them via freight and train. They sometimes ship it next day. They fulfill your orders whenever you want without you asking. Orders you forgot about from last January. They have no problem. They're like the ATF. They charge you right away, and then they just get it done kind of at their own speed, at their own pace.
Okay, well, I get
whenever they want.
excited if the SCOTUS is just going to stay that. We don't know if SCOTUS is going to stay that. SCOTUS stayed a district court's decision, not the circuit court. The circuit court has a little bit more weight than a district court decision, so we're not 100% sure.
Yeah.
I wouldn't be surprised if they do stay it, but I cannot say 100% that they will stay it. Another question here is, can someone elaborate on the mag, a mag band for pre-band mags? As I found a box of pre-band sticks, 940 and 45. If you are talking about the federal pre-band mags, there's nothing really. They're a collector's item. There's nothing on the federal. If you're talking about a state, that depends on the state, but federally, a pre-band mag and a post-band mag is the same. So
Yeah, the only difference.
People collect the pre-bands. So like pre-band ARs, they command a premium because people see them as a collector's edition, or like a collector's item.
Yeah, there was a time from 94 to 04 where there was a 10-year ban on assault weapons and high-capacity magazines. So you would find ARs with bull barrels, no threaded barrels, no bayonet lugs, no adjustable stock, no, just silly things that don't even matter, right? And then the high-capacity magazines that were manufactured during that time were manufactured with a stamp that said for law enforcement / military use only. Now, they weren't illegal to possess and to sell and trade. So you could possess them, use them, buy them, sell them, trade them. But for the ones that were newly manufactured, they had to be stamped for law enforcement military use only. So it literally did nothing.
Yeah.
Made the old ones expensive.
All right. This cannot really help out CRS firearms. NFA regulation says that anything that convert a semi-automatic machine gun into a machine gun in itself is a machine gun. And the argument via the ATF was that the auto key card was a conversion device. I totally disagree with that. I do not think it's a conversion device. I think it's just the novelty piece. But that is what they argued. So this is not going to be able to help them out, unfortunately.
Yeah, that's why bend over, you may see from time to time people literally engrave on like lowers for civilian use only, just to be funny and witty.
Right. Magpul PMag, you're good? Yeah, they're good.
I don't think they're good. I think they're great.
Yeah, they're good. So 180% is a go. 2 braces are also a go. Unclear for a few of us on braces with. Okay, basically, there's nationwide injunctions against the brace rule, and the majority of the rule and the frames and receivers have been vacated. So yeah, you're good to go for now. Now, any of this stuff can change because, as we've seen, it's been going back and forth. I do not like hex mags.
Hex mags are garbage. They belong in the trash. Yes.
I do not like X-Max.
Can you have full auto trigger grips just as long? Go ahead. You want this? You want to take it?
So it really depends on your ATF agent that's pulling you away in the silver bracelets.
No, you can have you can buy a full auto trigger pack group from Brownells.
Sure, you can buy an MP5 trigger pack for $99. Well, now they're like over $200. But hold on, we'll come back to this in a second. It depends. And Rich, I think that it's kind of what you were going, like it depends, right? On circumstances and other stuff, possession of other stuff, and so on. Right?
Yes.
Yeah,
Okay.
it really depends. Like, let's say you have a receiver, and you have a little indentation mark or a little mark where the third hole would go, and you have a full auto trigger pack. Well, you have a machine gun according to the ATF.
Yeah, if you have a rubber, if you have like a Rubbermaid bin with an AR in there, a sear from Brownells, and a drill and a drill bit just sitting like that, that's constructive intent in their eyes and stuff. But it depends. Like, I think this was what Rich was going to say, is that it depends on the situation, the circumstances, what else you have, how it's stored. Are they in different buildings? Because that's the only way that you can avoid constructive intent, is if they're in completely different places. But even that has been beat when people have fallen victim to that when they say, well, you had access to both locations.
Yeah, so Jordan right here is basically saying what we did. If it's marked where the drill, it's a machine gun.
Yeah.
100. Okay. 80% in California. Well, there is a state law against 80%ers in California.
There was.
Yeah.
So I'm not going to give anyone advice about this. However, there was a state law, and they were initially saying that they were going to allow people to get them serialized and then transfer serialized 80% frames. And you'd have to do a background check and purchase them lawfully through an FFL. But then on, I think it was July 1 of last year, not this year, last year, where Gavin Pubesum said, we're just going to stick with the current ruling that is the federal law, because he had an emergency, or I forget what it was. It was like an emergency order or some type of thing regarding COVID, so they could keep drawing it out. And then when July 1 hit, they had said, nope, we're just going to follow the federal rule, which at the time, like basically stating that California's law was the federal rule, which at the time, like you said, Rich, they were banned, right? Well, I don't believe they've gone back and updated that. So what it seems to me that people in California, it seems to me what they're doing is to play it safe. They are purchasing, buying, and selling the 80%, the P80 bridge frame, which is the ATF compliant. But I don't know. Some places sell to California, some places don't. I do ship jigs to California for the bridge frame. I'm actually the only company in the world that has jigs for bridge frame, but just keep that in mind. Be safe. Don't do illegal stuff. Don't get in trouble. And we're all comedians, and this is all satire. So don't pay attention to any of us.
All right, we
got somebody asking about the TLDR. The TLDR is 80% frames are now legal again nationwide, no matter who you are, what organization you belong to.
With frames, jigs, rails, drill bits, instructions.
The rule is vacated. Yeah, the majority of the rule is vacated, not the whole entire rule.
Basically, the frame receiver portion.
What are good mags? PMags are good mags for ARs. I'm assuming you're talking about ARs. If you're talking about AKs, I would always go with X-Tech. But PMags are good. USGI, which is what metal mag can be trusted these days.
Duramag, C products.
Yeah.
There are, so you can get old GI mags, take the guts out of them, and put the Magpul
Anti-tilt
upgraded followers in there.
Yeah.
Yeah,
Just
that
run
makes them. Yeah, they're totally 100% good to go.
All right, here we go. Johnny Barr says best mag he owns is the one with my logo on there. There you go.
I got two right over there, and I bought them,
two.
by the way. PSA metal mags are good to go. The black ones with the brown or FDE insert, those have run really well for me. But those are designed exactly the same as the Duramag C Products mags. So, depends on what's on sale, what you can get your hands on. Personally, I mostly run P mags, but I run the metal mags too, the Duramags. D&H metal are good. Yep.
All right. So Joe Biden says, okay, if someone's carrying a P80 and gets pulled over and states to the officer he has a weapon, what happens to that weapon? It depends on what state you're in.
Yeah. I've been pulled over carrying a polymer 80 in my waistband, and, I've had no problems at all.
Yeah. Okay.
Go ahead.
Let's see what the next question is. The TLDR, we just did that. And I can go ahead, Rich.
What would happen if you have a stencil? They sold those as long time ago, not to mention all the books on how to build your own fully automatic machine gun silencers, just saying none of those. Yeah. So if you have a stencil, and again, not legal advice.
I have from the ATF saying the stencils are okay.
Yeah.
Yeah, the ATF has said, I don't have a legal letter backing that up, that stencils are okay. As long as it's not engraved on metal.
Now, they also released a white paper saying that a perforated card with a lightning link in it was okay. And then 15 years later, or no, 20 plus years later, incarcerated one of our friends off of the same thing. So just, you use your best discretion, right?
Well, if it was paper, the ATF said it would have been okay. If it was a t-shirt, it would have been okay because it was made on metal. The ATF said, nope, that's not okay.
But the one that they approved in the 90s and said wasn't a machine gun was on metal and it was perforated.
Yeah, but there was another case in 2017 that was a little bit different.
Oh, interesting. Hey, Ron Wayne, good to see you. Anyone have experience with Lancer mags? Oh, Lancer metal feet AK mags? No. What do you guys feel about Lancer AR mags?
They don't really have too much experience at Lancer.
Yeah.
I'm telling you, the only old US Palm before Century bottom out is the only AK mags I would use that are not X-Tech.
I like the Romanian and Bulgarian just straight up steel mags.
Circle Ks are good too, but I think X-Tech are still the best one.
Circle K, the Circle 10s.
Circle 10s, sorry.
The 711s are great. Yeah, no, they are. The Circle 10 polymer mags are awesome. Circle 11 Polish are good.
No, okay. Mags. I just want to make sure this is clear. This only deals with federal regulation.
Yeah.
Not state regulation, just federal regulations.
Correct. You are bound by the state's laws of the state that you live in.
No, you're not bound. I mean, they want you to be bound by it. You can do whatever the hell you want, but you might just go to jail.
Yes, that's what I mean. I don't give if somebody does or doesn't follow the rules, laws, or regulations. I'm just saying that in their eyes, you are bound. You can do whatever you want.
What just if it's a bottle opener? Well, we know what happened with that.
Yeah. Doesn't matter what it is to them. Unxie Arms has a keychain that's one side of the lower with the third hole. That's just a.
The title of my video is exactly what happened. It's not clickbait.
The rule was vacated. What?
I mean, I didn't say. I try to avoid clickbait titles.
The rule's vacated. What should we do? Make a video that says the rule's vacated. Why would your title say that
All
the
right.
rule is vacated?
So we got a question here about Oregon's ghost gun law is dead before it goes into effect. Yeah, no, if they make it illegal, it's illegal.
No, well, Oregon, that's a state law.
Yeah.
That's not a federal law. Once again, this only applies to the federal law.
So what about the supremacy clause?
Well, I know what you're saying, the supremacy clause, but there's a difference between state law and federal law. Now, what it said, if the federal law says that something is illegal and the state says no, it's legal, then that's when the supremacy clause kicks in.
People are coming in.
You're late to the show. That was yesterday's show.
Yeah.
You're very late.
You're literally a day late and $1 short. Pistol braces, there is a national injunction. It's an injunction, correct?
Yeah.
Yes.
Yeah.
So pistol braces are legal again.
Yes. And
what about all the companies that used to sell PEDs and parts kits? They can do it again.
Yeah. Yep. At least till something changes. It could still change. So keep that in mind.
Like weed. That's a very good point. And yeah, it's kind of funny how they let that slide.
Yeah. Each of you, just don't break the laws and rules and stuff. Okay. Stay out of jail. You are more, you as an individual being here to be an advocate for our natural rights, you are more important and more useful out of jail than you are in jail. So snickering to yourself in your basement while drilling a hole in your receiver will do absolutely nothing for the movement of freedom, independence, and liberty. So let's fight together. I mean, not fight. I'm saying let's work together to earn our freedoms back.
But if you want to do that, just go right ahead and do it. I don't care.
Yeah, we can fight. And we can drill. We can drill, we can fight. Repeal the NFA. Yep.
I would one thing I discussed politics once before and decided with my family that's not the right thing to do, even though I was encouraged to run for an office, and it wasn't the right thing to do for my family and stuff. I'm too much into my kids. And also I would never run with Trump because he's a gun grabber.
Yep. We are here in part and mostly
mostly because of Trump.
Yeah.
He screwed us.
Yep. He gave the ATF the latitude. Now watch the viewership decline. Watch people leave because they're like, but Trump is gonna save me. Listen, we are here.
Not with our audience.
Well, it's a possibility. My apologies. I should have more faith in you guys. But the reality is that he gave the ATF the latitude that they needed to bring us right here for bump stocks that brought us
he
to...
said, get me a bump stock van. That's what he told the ATF.
Yep, that brought us to frames and receivers.
I've been dying to do that.
That brought us to, fuel filters and solvent traps. That brought us to pistol braces. Everything has brought us to this point from that moment.
Yeah, Trump did say last night he would defend the Second Amendment, but he also said the war against the Second Amendment was over than banning bump stocks. And said 20 years before due process. But I think we're done here. So you can follow Rich at Flying Rich Firearms, Flying Rich Official on Instagram, Flying Rich. And DLD After Dark, you have a show tonight, right?
I do have a show tonight. We're going to be talking about some incredible things, and you guys are going to love it. So check me out on DLD After Dark. I just want to say, Detective John Kimball, trust the plan. 2 more weeks, people. Yes, I have a YouTube channel, DLD After Dark, also on Rumble, Instagram, X, Twitter, whatever, all DLD After Dark. And Yeah, I have a store, DLD Hardware, for build DPU stuff.
And John Crump Live is going to be on a hiatus for a little while until I get some stuff worked out. So, yeah. More to come.
And rumors of sex change are really blown out of proportion.
No, nothing to do with that.
They're not blown out of proportion?
They're completely blown out of proportion.
Exactly.